wherever you feel easy. With this short, brief, and introduction, I would like to welcome Rajesh ji to lead us, please.
Thank you. Thank you, Matrika ji, first of all, for your kind introduction. And all the participants, मेरा नमस्कार आपको सबको. And
Namaskar.
Namaste,
it's
sir.
namaste, namaste. And you tell me, you want me to whenever you want me to do in Hindi or English, or you can ask question any way you want. I'm happy with that. Even if you want to talk to me in Bhojpuri, I'm also happy with that. So anything
Yeah,
will work. Or Mathili. So I
you
can I
can
can
speak
do.
Nepali too.
Nepali too, yes. So we can do that.
Yeah.
Um, it's very good to have this cooperation with the Gyanpunj School of Leadership, because this is similar, like in US, in Harvard is always the Harvard School of Leadership and the management and the law school, they always cooperate. So this kind of a cooperation is very good, and I'm sure NIAC and the Gyanpunj School, they are all leaders, and all the people who are here, I always consider them as a leader of ADR, and you have a highest respect from me, and I really give lots of credit to Nepal. And I have seen Matrika ji for many years leading from the front the development of ADR movement in Australia, in Nepal, and how far he has gone with that one. So this is my great appreciation for Matrika ji and NIAC and the further work. Now, I have been given task to discuss about the scope of international commercial arbitration in construction, in investment, in the banking and insurance, and cross-border transportation. Now, if I combine together, then it will all be, I can say it in two ways, is that one, we have to see it together as an international commercial arbitration and the investor estate arbitration or investment arbitration. So let's just say investment arbitration, and I will try to give you the synopsis and a kind of a snapshot that how close or how different it is from there for you to understand, because sometimes we reach a line where it is so difficult to define so clearly that we are whether we are dealing with a commercial arbitration or in investment arbitration. But so be it. The first thing first, the next slide, is that I have to acknowledge my country where we are here. We do it as a normal. So you can go to the next slide.
Next.
Next one. The very first thing is that go back to the basic to understand that why we call an arbitration domestic or international. How does it define? And you are taking the training. I see your curriculum. You have taken the domestic arbitration scene. If the domestic arbitration is based on model law, it is as good as international. But then where is the difference? How we can define an arbitration agreement is international or domestic? And we don't have to go very far. This issue was discussed during the drafting of the model law on arbitration. And the very first thing in the very first article, this one was considered, that how to define international. And therefore, the definition of model law, it says that an arbitration agreement is international if the parties to an arbitration agreement have, at the time of conclusion of the agreement, their places of business in different states. Now, I want you to mark few words here, is that parties to an arbitration agreement. Interestingly, parties to arbitration agreement, parties to contract, no, not parties to the contract. Arbitration agreement may be in a contract. In that situation is fine. But arbitration agreement itself, we have to look at who are the parties to the arbitration agreement. And then he said that at the time of conclusion of that agreement, mean at the time of conclusion of that arbitration agreement, if parties are from two different states, mean two different countries, then it's an international. That's the way we are looking at. So assuming there's a party from Nepal and another party from India, and they have signed a contract in 2020, but in that contract there was no arbitration agreement. They did not write the dispute resolution clause, and in 2025 now they have a dispute. So at the time when they are signing now and they decide that we have a dispute and we want to go to arbitration, and the both parties signing an arbitration agreement, which as you know it is called submission agreement, to take this dispute to arbitration, whether in India or China or Nepal, anywhere, when they want to take it, we have to look at the parties' situation in 2025, because that's the time when they are signing the arbitration agreement. Now we have to look at the parties. Are they still in India and Nepal? If they are still in India and Nepal, then in that case, it will be considered international. There's no problem with that. But in 2020, one party was in Nepal and one in India, but 2025 we have a dispute. And now we are signing a submission agreement or arbitration agreement, and the one party who was in India before now closed the business in India and moved to Nepal. So if in Nepal in 2025 both of them are in Nepal and then they are signing an arbitration agreement to take the dispute to Nepal or outside Nepal, then in that case the parties are only parties are not in two different countries. Therefore, it cannot be considered as international. So that's the key point. But 90% of the cases, what happens is the businesses, when they sign the contract, they include the dispute resolution clause. And at the time of signing of contract is also at the time of signing of arbitration agreement. And at that time, when both parties are in two different countries, then they are in arbitration. Then they are in, this is an international arbitration. So first focus is on the parties and the timing of the arbitration agreement. The second focus is said that one of the following places, if this is situated outside the parties have their businesses or the place of businesses, then it will be considered international. So in this case, what happens is that, assuming the two parties are from Nepal and they are signing an arbitration agreement, now there is a dispute or signing a contract with an arbitration agreement. And it said that in that arbitration agreement, they agree that the place of arbitration will be outside Nepal. So the two Nepalese parties can sign an arbitration agreement, but they consider that the place of arbitration will be Singapore. If that happens, then in that case, this arbitration agreement will be considered international, and therefore this arbitration will be international arbitration. This is important to understand that, because if you follow the guidelines from the court or the decisions from Indian courts on this point, you will be confused, because the Indian courts have taken a different steps. In the Indian law, which is not typical model law, in that one they have revised and they say that two Indian parties, if they are having a dispute arbitration outside India, then it will not be considered international. But according to model law, it should be considered as international. Even if the parties are domestic, place of arbitration is different, then it should be international. Why? Because in arbitration, the seat of arbitration is very important. And in this case, if the parties have selected the seat of arbitration in Singapore, it means the arbitration will be conducted in Singapore. Singapore court will have a supervisory jurisdiction, and the award which will be issued, it will be considered as award issued from Singapore. And since Singapore is a convention country, the New York Convention country, then this award will become a foreign arbitration award, and that's how it will be introduced. So this is the connection between the arbitration agreement seat and the arbitration where it's conducted, an award and the enforcement. So this linking, it proves a crucial point that even if parties are domestic, then the place of arbitration can determine that the arbitration is international. So this is very important for you to understand that many times we think that if the parties are domestic, then it cannot be international. That's not correct. So this is the thing you have to do it. Or the second part is that they have like their relationship, their commercial relationship or whatever the or subject matter of the dispute which is covered under the arbitration agreement has a close connection with the foreign jurisdiction. So here we say any place where the substantive part of the obligations of the commercial relationship is to be performed, or place with which the subject matter of dispute is mostly and closely connected, then in that case it will be international. So it may be possible that the two Indian businesses, they are constructing a resort in Nepal, though they are Indian businesses, but the most of the contract, the construction of the resort will be done in Nepal. And if the dispute happens because of the the resort, then again the subject matter of dispute in the arbitration agreement will be related to Nepal. So in that case, it should be considered international. So this kind of an idea, the in making it international, was very important at the time of drafting of international commercial arbitration in 1986 or 2000, when we were doing 2006, when the revision was happening. All these parts were very well discussed and described, and it was agreed that we have to give a wider interpretation and cover it as an international and let people have it. If we want to change into domestic, if you adopt it, that's different, but typically international commercial arbitration is based on that one. So much so that it is also given the parties autonomy, so much of, like, autonomy to them, that even the parties can expressly agree that the subject matter of the arbitration agreement is related to more than one country, not only Nepal, but partly it can be done in different places. So say for example, they can supply the material from India, partly supply from China, partly supply from Tibet, and all these, the Bhutan, and all these places is coming for the resort construction. Then the parties can say that my arbitration is related to more than one country. And if the parties have selected that and expressly say that, whether in arbitration agreement or whether in a contract, but it has to be expressly stated. If they say that, then the tribunal or the court have to accept that this is an international arbitration, and there cannot be any change on that. So this is the position of international commercial arbitration and the definition of international. We just assume that we know about international, we know about the commercial, but we always ignore the definition. And therefore my first suggestion to all of you, or any of my students and all, whenever we learn and teach this subject, we always say, go back to the definition, go back to the basic, and try to see that where is the difference, and then you will understand very well. So this is the internationality part. In this one it comes. So if we go to the next
Should they
slide.
have the part two flexible?
Sorry, is there any question?
No.
No, okay. So can we move to the next slide? Yeah, this is the next slide. Now, in this one, when we are talking about the place of business, particularly in the multinational companies, you can find that the company's registration place is one country, but their working place or their business place is in many other countries. In that case, we say that no need to worry about it. If the parties have a more than one place of business, then any business place which has a closest connection with the arbitration agreement, we will take that into account. So a multinational company, a construction company which has a registered place in Dubai, but they also have a working place in India, and from India they are conducting the business in Nepal and constructing the resort. Then in that case, the place of business of India will be considered, and that will be fine, no problem in that. And he said that if there is no place of business, then we just look at a habitual place of business. Habitual place of business is something that some company prepare or like establish a representative office in a country, where basically now these days they are just working with one computer, one table, and one chair, and that is even sufficient to claim that they are party and this is a habitual place of business. And even that kind of a foreign connection we have, then we can declare it as an international commercial arbitration. Many countries have adopted some other approach. For example, China. Uh, China uses that if any foreign element is involved, and their foreign element definition is itself, there is no definition, but from the cases and examples, if you collect it, then you can find the simple thing, parties or place of business. But one important point is that they say that the transaction, the money involved in the deal, and if the money involved in the deal is US dollar or foreign currency, not Chinese currency, then in that case also they consider this as a foreign element involved, and therefore it becomes an international arbitration. So this is the international arbitration or the internationality part of it. Now going back to the commercial one, uh, it is not just international, it's international commercial arbitration. And the people always say that where is the definition. And recently I was giving a keynote in Tokyo, and there was an this discussion came, and government representative from one country, they were there, and they said that where we can find the definition of commercial. And I had to tell them that go and look at ancestral model law, and they said that sorry, I cannot find it. And the reason they cannot find it, because this definition is not in the text. You can get it in the footnotes. The second footnotes of ancestral model law gives you this definition. And if you read this definition, you will be surprised that what we have here, it says that the term commercial should be given a wide interpretation so as to cover matters arising from all relationship of commercial nature, whether contractual or not. And I'm sure the word whether contractual or not, you remember, it also appears in the definition of arbitration agreement. It means we are not only talking about the contractual, and it's a contractual or not means even the tortious relationship, tortious dispute is also a relationship, and that can be covered under commercial. So when we were in the law school, we will all say that contract and tort are two different things. But here, if, for the definition of commercial, even the non-contractual transactions or the relationship can also be considered as commercial. Very wide. And then it says the relationship of a commercial nature but are not limited to the following transactions. And now look at this: trade transaction, supply or exchange of goods or services is a cross-border transportation of goods we are talking about, which is generally happens under export and import and happens under the international trade regime. Even that is considered commercial. Distribution agreement, commercial representation or agency, this is also commercial. Factoring, leasing, and here is the topic which you are interested, is a construction of works. And all the construction comes under construction of works. Works is defined even bigger. So anything you construct, they will all be construction work. Consulting, engineering, licensing, and even the word you will see investment. And we are going to talk about investment arbitration, and you know about investment arbitration. Even the word investment is given over there. So financing, banking, insurance, everything is there. Exploitation of agreement, concession, joint venture, industrial, business, cooperation, carriage of goods, passenger, transportation, sea, rail, road, everything. So now if you look at that, whether it's a maritime transport, export, import, construction, mining, minerals, exploration, everything is included in commercial. So if the commercial is so wide, it means we can cover any kind of commercial dispute under the international commercial arbitration. It's so wide. But then again, technically we have some kind of a changes. So if you go to the next slide, um, then we look at that. What is, if we know the international and we know this is such a wide commercial, then everything should fall into the international commercial arbitration. Then why we have a investment arbitration? And the investment arbitration has everything like a commercial, but only one thing is that we have to look at the parties. And the parties in investment arbitration, you will always find a state or a state-owned enterprises is one party. But then so can happen in any commercial dispute too. You can have a commercial relationship with a government. Say, for example, you supply the computer to Gyanpunji school, which is perhaps like owned by the government. Then it is the contract between the government agency and the private agency, but it's a transaction of computer, export import of computer. These are all commercial, not international, not investment. So why we look at investment? The another thing is that,
राजेश जी just a
yeah,
moment please. पूनम जी, पूनम जी सबको, राजेश जी बाहेक सबको माइक्रोफोन अफ गर्न मिल्छ?
Okay, sir.
राजेश जी प्लिज
okay.
प्लिज.
So in that case, if we focus on the parties, because the parties also tells us about the government, about the commercial arbitration and international. So here, if you look at that, um, there's a one party is a foreign government, and the another party is a foreign investor. So foreign investor and the host government, they are the party. Over there, the investor, they invest in the host country and they request for the protection of the investment, and that's how the investment arbitration comes. It was generally designed in 1960s for one purpose. Just little bit to tell you, in 60s, when the developing countries and the least developed country wanted to develop, and in UN there was a resolution about the right to development, which has now been extended quite a lot. So the idea was that this country has to be developed. Now we have to improve, but they have no technology, no resources, no money. So how we can develop them, how we can help them? So the World Bank organized this idea that the developed investor from the developed country, means big companies, and the government from the developing and least developed country, can join together, and they can come out with the situation that investor, or the developed country investor with the money and technology, they will go to the developing and least developed country and construct, mine, or do some business, some construction work to create infrastructure in that country, help the government to do the public work, and therefore the local government, the host government, will improve. So we need those kind of things. Many countries, they need road, they need bridges, they need hydropower, but they don't have a capacity, they don't have money, so we need somebody from outside. But the business people are business people. They say that I'm dealing with the government, I'm a businessman, if I invest money, I want return on that, I want profit from there. And that was the idea. So in order to maintain the profitability, and also to protect those investors so that the government cannot take over, because in 60s there was also an idea that whenever a foreign companies they establish something, the local government took over that property, took over that business. And it happened quite a lot in Cuba. All the American sugar company were taken over by the Cuban government under the Fidel Castro regime. So the American government or the World Bank, they knew about it. So therefore, they wanted a protection from the government. The investor can invest, but there has to be protection. And the one thing was agreed, that let's do it through the arbitration, and we will call it a foreign direct investment, and we will call it for the development of the local countries, or the least developed country, or the developing country. And if there's a dispute, we will go for arbitration. And the arbitration will be under ICSID, and the place of arbitration is by default is in Washington. So out of the country and under the umbrella of World Bank, so under the ICSID, and therefore it will be well run and well conducted, and therefore the government influence will be less. And that's how the investment arbitration came. So the focus is only the government and the public good, but it can also be reflected in the commercial arbitration. There's no doubt about it. So China made a airport in Philippines. There was a dispute, and the parties said that this is a commercial dispute, and they went for the commercial arbitration. But in same Philippines, Frankfurt Airport Authority, Fraport, developed or constructed an airport over there, which went in the several dispute, and that dispute was fought in under the regime of ISDS, under the investment arbitration. So how come in the same country one airport is considered as a construction, and another dispute considered as investment? And that creates a kind of a blurring the line between commercial and investment, because of the definition and because of the utility. So if we go to the next slide, we will see that investment arbitration has a particular legal regime. If you look at the commercial arbitration, you don't find a particular law governing. We only the law of arbitration, which is model law. Contract law can be designed, can be accepted by the parties. But when it comes to investment arbitration, the choice of law or the applicable law is very, very different. And you can see that origin of that, you will find it under the ICSID convention, or you can find it under bilateral investment treaty. So remember the word treaty in international law. And you can also find in the free trade agreements, you can find the investment regime. So since it's a treaty, which is a kind of like treaty in international law, so the treaty has a higher hierarchy, the number top hierarchy in international law, as we know. The second one is a customary international law. So when we use the applicable law in investment arbitration, then we have to use international law. And when I'm saying international law, I'm saying customary international law. So the customary international law also comes into play in in investment arbitration. But in commercial arbitration, international law has no chance to come, or very rare opportunity to come. Customary international law, no way it will come, unless there is some special circumstances. Otherwise, it will not happen. So Commercial arbitration, very party dominated, privately arranged, law collectively selected. But in investment arbitration, we can have international treaty, we can have a Vienna Convention of Law treaty for interpretation of treaty, and we can also have other legal regime like customary international law to apply in that one. So this is very important and interesting part which we need to remember, and that distinguishes from the commercial to investment arbitration. So sometimes by looking at the law applicable, you can also decide how the arbitration has done, or whether we should say commercial or in or investment. So if you go to the next one, um, in investment arbitration, there's an arbitration agreement. In commercial arbitration, parties have already agreed an arbitration agreement. But in investment arbitration, there is a standing offer of arbitration, meaning the host government has given an offer to arbitrate with any investor who will come and invest in his country. And if there is a dispute, then the government has offer given the offer to arbitrate. The investor just have to accept that offer to make the arbitration agreement binding. And this principle is based on a contract principle of offer and acceptance, typically of that. So whenever there's a standing offer in a contract, any party can accept it. Similarly here, the host government has given a standing offer. This idea of a standing offer automatically comes in the exit convention by signing the convention. It comes under the treaty, bilateral investment treaty, just by signing the bilateral investment treaty, or just by signing the multilateral lateral agreement like CPTT and all the or FTA and other, or ASEAN in our case, SARC in our case. All those things, if you look at that, over there the investment agreement is there. Just by signing those agreement, government accept that if we have a dispute, then the government is happy to sign, happy to go for arbitration, depending on the investor if they select it and accept it. Interesting difference from the commercial arbitration and investment arbitration here is that the investor is not even a signatory to the treaty, not even signatory to the exit. It's only the government, the state to state, the signature, the country can sign. Not even the third party, like investor is a third party, but the third party is the best or the most beneficiary of this arrangement. And this is very unique regime. In our commercial arbitration, you learn that if you are not a signatory to arbitration agreement, you can't even arbitrate. But in this case, an investor who is not a signatory to investment BIT, who is not in signatory to even BIT or in exit, still those investors have a right to go for arbitration because the government has given, the host government has given a standing offer. And how this offer is accepted? This offer is accepted by issue the notice of arbitration according to that procedure. And the moment the investor issue the notice of arbitration to government, then or intention to start the dispute in arbitration, notice of that kind, then it all consider that the investor has accepted the offer of arbitration and now they are continuing with that. So this is the fine difference in commercial and investment arbitration. If you go to the next slide, you will see the typical, the standalone and very important and very famous arbitration agreement in investment arbitration under the exit is Article 25. And it says that the jurisdiction of the center shall extend to any legal dispute arising directly out of an investment. So the points to remember here, the jurisdiction. In a commercial arbitration, the jurisdiction is dependent on the parties' agreement. In here, the jurisdiction is dependent, or a standing offer of the jurisdiction is given by the host government, not by anybody else. And he said the jurisdiction of the center means jurisdiction of exit, and he said shall extend to any legal dispute. Of course, it has to be there, but arising directly out of an investment, not a commercial relationship, investment. Now, you will be very surprised that this word investment has also appeared in the definition of commercial arbitration. So the word commercial includes investment, and here we are using the word investment. And if you look at the history and the drafting history of ICSID, you will never find the definition of investment. It was never defined, never agreed, though they tried it. But it was so, like, debate and hotter discussion over there, that they decided to drop this idea. And they said that parties, means investor and the host government, they know what the investment is. So therefore, we will not go and define it. However, Professor Shore, he looked at the drafting history and come up with the idea, like, the discussion, and put it all together and created a kind of a definition of investment. That is not the official definition. However, in the cases now, we use that definition forever. And we say that definition has certain characteristics. It says that it must be an investment by by a investor. It should be for the public purpose. It should be for a certain duration, and all those things he brought in there, and we use it. And the first time this definition was used in Salini case, so therefore we also call it Salini test. So you will see this one. However, officially we cannot say that this is the definition. So that's the one point. The second point is here, is that it says that contracting estate and the nationals of another estate which the party to there. So who are the parties? It could be a national of another estate and the host government. When we say national here, it has to be defined national for a company and for individual. So the company is very easy. Wherever the company is registered, the place of registration is the nationality of that company. So we will look at it, whether those countries are signatory to ICSID or not, and then we will move. For example, India is not signatory to ICSID. So any company which is doing business and want to have investment dispute, India cannot go under the ICSID. They have to do it as a commercial arbitration or some other places. It will not be considered. But when it comes to individual, and by the way, in ICSID, in investment arbitration, even an individual can be an investor, and therefore he can start investment arbitration, and we have multiple cases on that. But how to define the nationality of individual? Because a person can have a multiple passport. Many countries where the dual nationality is not prohibited, they start taking it more and more. So a person can be from India, not nationality of India, from America, but he can also have a passport of like Canada, Australia, UK. So how we define that the person is having which kind of nationality? And sometimes this individual dual nationality or multiple nationality creates a problem. But in the definition, you will only find national. So I want you to only to focus on this idea of investment. And this is the core, this is the subject matter of dispute in investment arbitration. So if we go next, that one, you will see certain conditions which the government says, and that's how the conditions emanate from the exit agreement from there. It said that, like, before, the government has said that I have given you the standing offer, but even if the standing offer is given, a proper acceptance can only be considered if there is an investment. So it has to be an investment dispute, and it cannot be a commercial. And here is the problem. When we say something is investment, this is also commercial, like whether you call a stock, share, intellectual property rights, licensing, concession, construction, these are all comes under the definition of investment and also comes under the definition of commercial. So, but we have to say here that there's an investment. And the one way to look at it, whether the person has invested in according to the BIT, or whether he wants to use the BIT or not. So if I'm an investor, I want to start the claim, I can decide whether I want to go to commercial arbitration route or I should go to investment arbitration route. So it's my choice and I can choose that. But if I choose to go to investment side, then I have to prove that whatever I am doing it in that country is my investment. And the definition of investment, you can find it in the BIT, in the bilateral investment treaty, which I'm using it. Interestingly, investment has no limit. You cannot define how much money can consider as investment. Even $1 technically can be considered as investment. And there are cases, can you believe it, in Malaysian historical Salver case, the dispute was only of 500,000 US dollar in terms of investment dispute, we call it, is less than peanuts. In that one, nobody cares. The lawyers charge more than 500,000 in that case, and the whole Malaysian government was fighting against the UK investor for 500,000 fee. So you can imagine, so there's nothing. Even me buying a $1 a stock in an American company, I can become an investor in America. And my rights have to be protected, and I can start an action against the American government if I have any dispute. So this is the part of it. So the money was never considered in that case. It's also said that if you want to find the definition of investment, you should first look at the BIT or FTA, whatever you are using it, use that. Why? Because BIT is a treaty, and in the interpretation, hierarchy of treaty is number one. So therefore, we have to start from there. So even if there's no definition over there, as an arbitrator, when you act, you must say that I looked at the BIT, I could not find the definition over there. I asked the lawyer to point me that or take me there. They could not, and they agreed that there is no definition given in BIT. Therefore, now I am going to look for the definition of investment from other sources. And then they will bring the idea of customary international law, previous decisions, and all. And then they will say whether this investment is decision treaty or not. In again, the in Malaysian historical Salver case, a very top arbitrator, he knew that the definition, the treaty does not have the definition, and yet he did not write it in his award. Just because of that, his award got annulled, and saying that why didn't you use treaty first? And everybody knows that in treaty there is no definition. So he said that why I have to follow the mechanical route? But the annulment committee said that no, it is a matter of procedure and you must follow that. And only on that ground, and many other ground, but one that important ground, the whole case was rejected and set aside, annulled in the exit sense. So the which law you apply first, that is also very crucial in investment arbitration. Another thing is that whatever you are doing, investors must be from the other country. That is a part of it. And the dispute must be related to investment, and it has to be a legal ground. Some kind of a legal ground should be there. For example, if you have an investment and by bribing the government official you get the contract, then it's already become corrupted, tainted, and in that case it is not a legal investment, because no country will say that, oh, investment by giving the bribe is a good idea. Then they will say that this is not an investment. And if it is not investment, then the dispute is not investment, because you did not invest legally. So this becomes illegal, and therefore this dispute is out of the jurisdiction and it will not happen. Okay. Um, Another thing is that if you are using the BIT, make sure that your investment arbitration start after the BIT sign, not before that. So this is important part, and it has to be investment according to law, means there no corruption should be involved in that one. So these are the conditions. Apart from the arbitration agreement, apart from the exit signature, these are the things we need to follow that. So these conditions must be satisfied. So if we move forward in the next slide, is that I have just given you a typical example from a BIT signed by the countries. If you look at that, every BIT, you will find most of the BIT, you will find the definition of investment, and they will always say the investment in host party law shall include every kind of asset in particular, but not exclusively, meaning they open it and they include. So share stocks, all company, investments, claim of money, everything is considered, and the claim of money under the commercial arbitration award, if a party has a claim of money and they are not getting the money back, then against the estate they can even start investment arbitration on that basis. There have been 5-6 cases on that idea, and you can have it. So this is again the link between the commercial arbitration, award is given and the award is not recovered, then you can start the investment arbitration on that one if you have a party against or you have enforcement against the government. It also says movable and immovable property, mortgage, lien, place, everything. So this is like construction project can come. Copyright, industrial right, intellectual property right, means the IP right, technology and everything is covered. This is considered as investment. And the business concessions, which is like mining contract and all these oil exploration contract, everything will come under that. So this is a typical example. But if it says that but not exclusively, means these are just an example. Now you can use the sui generis interpretation, and you can bring more and more part of activity as a part under the definition of investment. So this is the lawyer's exercise to be creative and then work on that one. If we go to the next one, is that idea is that how we can distinguish the commercial or investment. And this is very tricky part, because one, if the investor already decided that I want to use BIT and I want to claim everything under the BIT, then that's fine, then it's easy. But if they decide to choose the commercial route, then even if it's an investment, you have to go as a commercial dispute. And I give you an example of construction work in Philippines. It is a typical example. Airport project by China was considered commercial project, and it was litigated. Sorry, the arbitration was done in Singapore. And when the enforcement and everything, they said that this is just a commercial contract, and we agree that it's a commercial contract. However, another airport project is considered as investment project. So this is very, very interesting. There's no definition. India considers that there's nothing called investment. Few years ago, India withdraw from all BITs, and they said that investment dispute are basically construction dispute, and therefore we will treat as a as a commercial dispute, and that's it, nothing more than that. But that is not true for every country in that one. So if you think about the construction of a school, hospital, hydropower, road, what should be considered? In general, we consider this one. If the foreign parties are involved, then we consider as an investment. Why? Because providing a school, hospital, electricity, power, road, all those things is a duty of the government to provide for its citizen. And if the government is not providing, asking somebody else to help them, then it should be considered as an investment, because it is for the public good, it is for the development of the country. And if that is the case, according to ICSID definition or FDI definition, it should be considered as investment. Now, bank loans, bond, restructuring of loan, interestingly, all these things have been considered as investment, and there are many cases. CSOB case was first one, which was very good on that one, where the bank has given the loan to the government. But again, one party was the government, or the bonds were issued by the bank or a state-owned bank. Customers, they got it in AppClat case against Italian investor against the Argentinian bank. The bank is owned by the government. They issue the bond, foreign buyers, they bought it, and later on the government said that I will not honor the bond, but we will restructure the loan. So what happens in the restructure? You have to take the lower value of your money, and that is a kind of either you lose all or you take some. So sometimes they agree to restructure, take the lower amount than what they have invested. After the structuring, Italian shareholders of the bank or the bond holders of the bank, they sued the foreign government and they won. The idea was that this is an investment and those people are investors in that case. We can consider that. But the bank and customer and the creditor or the loan, the debtor, all these people, when you have a bank in Nepal and the customers are Nepali and they are having a business and the loan issue is concerned, that will be a domestic, that will be a commercial dispute, not an investment dispute. Okay, so this is the difference. If you have an insurance, one is that insurance policy given to the customer, that will be considered commercial, or you can say consumer dispute. However, if the insurance merger is concerned, joint venture is concerned, and something the government has done, say for example, government said that the 50% foreign partner, 50% local, they can establish a new insurance company in the country and they can do the business. But later on the government changed the law and they said that no, foreign party can only have less than 50%, not 50%. In that case, the law has changed. It has affected the profitability of the insurance company. Then it is considered as insurance. It will be considered as investment cases. So some cases of this type also we have seen in investment. But Insurance company versus consumer or policyholder, that will be considered as a commercial or consumer dispute in that case, not investment. And it also depends whether the investment, whether the insurance company is a government or not government owned. Cross border transportation of goods, this one is will be considered international or commercial. It is very less likely that it will be considered as investment, because investment has a definition of movable, immovable, to be there in the country for the development of country. So cross transportation of goods like export import, in that one you look at that maritime, by road, it's all commercial. We can say transportation, export import is comes under the international trade. So either it's international trade or it can be commercial, but very less likely that it will be investment cases. However, in two cases where SGS Pakistan, SGS Switzerland, over there the serving company only has a duty to pre-inspect the goods, and only that part of the thing was considered as investment. And that part of the thing, that SGS company only had one table, one chair, one computer. They were only operating from there, not even a big company, big office, big space, and still they were considered as investor. So some cases we have seen it, but mostly these cases will happen at the transportation part. And in WTO, we deal with that if the country to country it has a problem, like duty. Recently, the Trump has said that they will increase the duty by 25%. The goods will be transported, goods will be exported. It is part of the commercial deal. But when goods will go over there, the duty will be imposed. That will be the governmental regulation, and that will be considered as a domain under the domain of international trade, not investment and not commercial in that one. But however, if you are making the railroad from one country to another, like Belt and Road, which we see now, going from one country to another country, that will come under construction. It is railway line or seaport and all those things which you make, that will be considered as investment. But the carrying of goods from one place to another place, export import, will not come under that. There's another, in BIT, you will see an umbrella clause. Umbrella clause is something that the way, the moment it applies, it makes a commercial contract of a higher level and makes it an investment. Meaning over there, you have to prove that I have a commercial contract with the government for public good of such a high level that it is for the public benefit. And I was involved in that one. In that case, it should be treated not as a commercial contract, but as an investment dispute, or investment as an investment. And therefore, it will be an investment dispute. So sometimes a commercial dispute can be pushed up in the investment circle. So commercial dispute or commercial contract can be investment. So these are the few things, like, you will know, and you have to be careful about it. So far as enforcement is concerned, we have two ways. If it's a commercial arbitration, use New York Convention in international commercial arbitration. Very good. Now we have 180 countries already over there, so no need to worry. However, in investment, there are two ways. If your country is party to exit, then there is direct enforcement under the exit convention. From one country to another country, you can go and enforce. But if the country is not an exit country, then you have to use New York Convention mode to enforce it. So both regime will apply at the same time in some cases in that one. So if we go to the next one, um, the challenges in enforcement, which we have to talk about in the next slide. I tell you that in next slide, we have three major challenges. And the one challenge I bring it very up for you to discuss, and whether it's a commercial or whether it's an investment, two things will definitely happen. And in those arbitration, if the party is a government, in investment, definitely the party is a government. And in commercial contract, if one party is a government or a state-owned enterprises, the sovereign immunity is the one defense which the government can always use. The sovereign immunity means that if a country follows the absolute immunity, then in that case, a foreign government cannot be sued in a different country. So you can't sue. And it's like one country should treat, one king should treat another king in the same way. So because of this committee of rule, we always decided that we will never bring a foreign company or foreign government or foreign companies, foreign state-owned enterprises as a defendant in my country. We honor them, so we don't do that. So that's the one part. When it comes to the arbitration, generally in New York Convention and other, when the New York Convention was negotiated and drafted, this issue was left because the governments were very, concerned about it, because they said that what happens in the foreign party, then what is our control? Then the parties can decide everything for us, and our court, our judiciary will just act on the basis of what parties have decided, and we have no control. So in that case, they say that no, we will control, we will give you the sovereign immunity to apply on that. Interestingly, a government can sign an arbitration agreement to do a commercial activity, a contract. They can do it. And at that time, the sovereign immunity is considered waived because the government has agreed to come to the arbitration. So when they go for arbitration, arbitration agreement compels them to come to arbitration, same as a exit convention. But when it comes to enforcement, government, they use arbitration agreement. And my argument is that this should not be there. We know that this is the policy, this is the thing has been given in the hand of the court to revisit this and re-engage and once again take over the jurisdiction over the defendant. In one case is a government. So I'm saying that, and according to international rule, or according to the rule, it happens that unless until the government has expressly waived their immunity from the jurisdiction. So the problem is the government, when they sign the arbitration agreement, they waive the jurisdiction from the arbitration tribunal. But when the same arbitration agreement cannot be considered as a waiving the foreign court jurisdiction. And that is a problem. This is the biggest challenge we have. And the same problem we face in internet investment arbitration. And therefore, none of the investment arbitration you see can be enforced in anywhere, and there's lots of difficulty because you can't go to Argentina and enforce the investment arbitration decision against Argentinian government, because the Argentinian court will never honor that no matter what. So, but you have to go somewhere else. So this sovereign immunity concept is very against the principle of arbitration, because arbitration is about commercial. So arbitration agreement should be considered as a waiver of immunity from the jurisdiction at the time of arbitration as well as at the time of enforcement. That's what we should do. And we have to think about it again, and we have to change. So that's the one consensus we have to develop. Second problem is arbitrability, because there's no one definition of arbitrability. It has been left to the local government to decide what is arbitrable according to their local law. So when it comes to enforcement, we are subject to the local law, which we have never agreed. It is just because of enforcement we are going over there. And if arbitrability is an issue, then no matter what we have done, how well the arbitration has been conducted, just because a country where I have to enforce and there the law does not permit me on that subject matter of arbitrability, then my enforcement will not succeed. And one typical example is now intellectual property dispute. There are 11 countries now which have said that intellectual property disputes can be arbitrated. And if you look at the definition of commercial, in that one, you have IP rights, licensing, and every copyright, everything is included over there. It means that is considered as commercial. And if it is commercial, then why it is not arbitrable? So if 11 countries like Singapore has allowed, so if we have an arbitration in Singapore, we have an IP dispute, we arbitrate, this is very good, no problem. We can do it without any problem. But if we take this one, go to India and try to enforce, I cannot, because the Indian law and Indian government does not allow us to have intellectual property dispute arbitrated. That's the problem. So 11 countries can honor, some countries cannot. And this is again left in the hands of the local government. And the last is the public policy, which is very notorious. And if you look at globally, it's not that bad. We have a good reputation. Even in New York Convention, the public policy, the French version, which was very wide, it was given the bracket to indicate that we want to use the narrow public policy. Only it says that which is very important core values of the country, morality and everything, then we should do that. So it was very easy, nothing on. If you think about the public policy ground, internationally, not many times have been used or not many times have been successful. But again, I tell everyone in Nepal, if you are learning from your neighbor like India, I don't want you to learn from Indian practice of public policy, because the courts over there are everywhere. Every day they come out with some definition which is totally useless and not in line with the international public policy regime or international arbitration. So it's very confusing. I was tracking it, I was following it, but I have left discussing about the public policy in India. That so these are the three main challenges which we have as a community. If we have to do anything, we should think about that, how we can use arbitration agreement to also consider as a waiver from the enforcement jurisdiction, so that we can bring the state to the court and enforce it. So this is my last, and my last slide is just to conclusion, to thank you and say that all these things what I have presented to you is just my view, my experience, which I want to just want to share with you. But I may not be correct on everything, and I'm very open and very happy to take questions and your comments. And if you disagree, please let me know. And any other views you have, you are welcome. So thank you very
Thank
much for
you.
your time
Thank
and
you so
attention.
much, Rajesh ji. I could have a request to you. Could
Yes,
you
sir.
summarize your presentation within a 5 minute in
Ah.
Hindi, please?
Hmm. Okay. Very good.
Yeah,
Um,
please.
okay. Let me try. Switch
Yeah,
from
please.
Hindi to English to Hindi.
Oh, yeah.
Okay.
You have to switch on.
हाँ, जस्ट संक्षेप में मैं
Yeah.
आपको ये बताऊं कि आपको कैसे पता करना है कि कौन सा आर्बिट्रेशन देशीय है और कौन सा अंतर्राष्ट्रीय है, कौन सा राष्ट्रीय और कौन सा अंतर्राष्ट्रीय। अगर ये आपको पता करना है तो सबसे पहला काम है, देखिए कि पार्टीज जो आर्बिट्रेशन, जो जो पार्टी हैं आर्बिट्रेशन में, जो दो दो वादी और विवादी जो पार्टी हैं उसमें, उनको देखिए आप, और देखिए कि वो कहाँ से आते हैं, किस कंट्री से आते हैं। इफ और ये दोनों अगर दो कंट्री से आते हैं तो एकदम आप कंफर्म हो जाइए कि इंटरनेशनल आर्बिट्रेशन, अंतर्राष्ट्रीय आर्बिट्रेशन है ये। ठीक है। आर्बिट्रेशन इज व्हाट इन हिंदी?
Arbitration is arbitration.
आर्बिट्रेशन, राइट, ओके,
We
हाँ।
understand.
अंतर्राष्ट्रीय आर्बिट्रेशन, हाँ।
Yeah.
तो ये हो जाएगा। दूसरा, ये देखना पड़ता है कि अगर पार्टीज, अगर ये अपने आप में डिसाइड कर लिया, अपने आप में समझौता कर लिया है कि हमारा आर्बिट्रेशन अपने कंट्री में नहीं होके एक फॉरेन कंट्री में होगा, विदेश में होगा, तो अगर आर्बिट्रेशन का जगह और कंट्री और देश अगर हमारे देश से बाहर है तो वो ऑटोमेटिकली वो इंटरनेशनल हो जाएगा। और ये बड़ा ये आपको समझने की बात है, क्योंकि इंडिया में ये होता है कि अगर दो इंडियन कंपनी अगर बाहर का, अगर इंग्लैंड में आर्बिट्रेशन करने का सोचती है तो इंडियन गवर्नमेंट बोलती है इंटरनेशनल नहीं है, जो कि करेक्ट नहीं है, जो कि सही नहीं है आपके अनसेटल्ड मॉडल लॉ के अनुसार। तो हम चाहते हैं कि आप सही चीज़ सीखें, हम चाहते हैं कि जो रियली इंटरनेशनल है वो चीज़ सीखें, गलत चीज़ ना सीखें इधर उधर से देख के, ठीक है। तो वो ज़्यादा इंपॉर्टेंट है। तो दो चीज़ याद रखिए, अपने पार्टीज को देखिए वो किस कंट्री से आते हैं, और दूसरा जो आपका आर्बिट्रेशन का जगह कहाँ है, कहाँ पे आर्बिट्रेशन करने का समझौता किया है। और तीसरा सबसे वो है कि अगर पार्टी अपने आप से एग्री कर ले, दोनों मिल के डिसाइड कर ले कि नहीं हम चाहते हैं कि हमारा ये आर्बिट्रेशन, हमारा जो है समझौता, इसको इंटरनेशनल माना जाए, क्योंकि हमारा बहुत सारा कंट्री हमारा इन्वॉल्व है इस पूरे डील में, तो ये इंटरनेशनल होना चाहिए। तो अगर ये होकर हो जाता है तो आपका ये इंटरनेशनल आर्बिट्रेशन हो जाएगा और अंतर्राष्ट्रीय आर्बिट्रेशन होगा। दूसरा हमने ये बताया कि आपको बहुत जरूरी है कि ये समझना कि कॉमर्शियल रिलेशनशिप मतलब वाणिज्य रिलेशन, वाणिज्य रिश्तेदारी क्या होता है। हाँ,
ठीक।
वाणिज्य, ठीक
Yeah.
है,
Yeah.
वाणिज्य रिश्तेदारी।
ठीक है।
अब वाणिज्य रिश्तेदारी मीन्स बिजनेस वाला, मनी वाला। तो जहां भी मनी इन्वॉल्व हो, समझिए कि आपका काम हो गया। और मनी किसी भी तरह का हो सकता है, खरीदने बेचने का हो, एक्सपोर्ट इंपोर्ट का हो, आयात निर्यात का हो, और या फिर बिल्डिंग बनाने का हो, रोड बनाने का हो, बांध बनाने का हो, पुल बनाने का हो। ऑल ये सब जितना चीज़ है, ये सारा चीज़ माना जाएगा कि इसमें पैसा इन्वॉल्व है। और जब पैसा अगर है, जो एक आदमी देता है, दूसरा आदमी लेता है, दूसरा आदमी बिल्डिंग बनाता है और दूसरा आदमी पे करता है, जैसे ही इस टाइप का ट्रांजैक्शन है, समझिए सब कॉमर्शियल है। सो एकदम बाप बड़ा ना भैया, सबसे बड़ा रुपया। सो अगर रुपया इन्वॉल्व तो मतलब कमर्शियल हो गया, बस सिंपल बात ये है
गुड,
उसमें।
थैंक
ठीक
यू।
है। अब अगर इसमें से अगर दो हम लोग देखें कि दो पार्टी जो हैं वो लोग बस नॉर्मल बिजनेसमैन हैं, तब तो कोई प्रॉब्लम नहीं है, तब तो आर्बिट्रेशन हम लोग कर लेंगे, ये बोलेंगे ये कमर्शियल आर्बिट्रेशन है, ठीक है। लेकिन अगर उसी में से एक पार्टी अगर गवर्नमेंट हो जाती है या गवर्नमेंट एजेंसी हो जाती है, तभी आपका एंटीना खड़ा हो जाना चाहिए और सोचने लगना चाहिए कि अरे ये क्या हुआ, अब तो ये दूसरा पार्टी तो गवर्नमेंट है। अगर दूसरा पार्टी गवर्नमेंट है, तब भी हमारा जो है आर्बिट्रेशन जो है वो डोमेस्टिक होगा, चाहे इंटरनेशनल होगा और कमर्शियल होगा, नो उसमें कोई प्रॉब्लम नहीं है, हो जाएगा वो। एक ही दिक्कत आती है कि अगर हम एक पार्टी हैं जो चाहते हैं गवर्नमेंट से लड़ना, तो हमारे पास चॉइस है कि हम जाना चाहते हैं अंतर्राष्ट्रीय आर्बिट्रेशन के लिए, और हम चाहते हैं कि नहीं, हम इसको और बड़े लेवल पे ले जाएंगे, हम इसको इन इन्वेस्टमेंट और लाइक इन व्हाट इज द वर्ड ऑफ इन्वेस्टमेंट,
लगानी, लगानी।
लगानी, हाँ ओके, लगानी वाला है ये। तो कहाँ जाएं हम? तो अगर हम चाहते हैं इसको लगानी वाला विवाद बनाना, तो हम उसको कर सकते हैं। तो उसके लिए हमको एक ज़रूरत है कि हमारा देश और जिस गवर्नमेंट से हमको डिस्प्यूट है, वो दोनों के बीच में कोई एग्रीमेंट है कि नहीं, वाणिज्य वाला कोई लगानी वाला कोई एग्रीमेंट है कि नहीं। अगर एग्रीमेंट है तो हमारे पास चॉइस है। और हमारा दो देश जो है, अगर वॉशिंगटन में इक्सिट कन्वेंशन का अगर हस्ताक्षर किया हुआ है, उसके तरफ बाध्य है, तो हम उस कन्वेंशन को यूज करके हम जो है ये लगानी वाला प्रोग्राम और लगानी वाला जो है सो विवाद खड़ा कर सकते हैं। और उसके लिए हमको जाना पड़ेगा वाशिंगटन में, या हमको जाना पड़ेगा दूसरे आर्बिट्रेशन सेंटर में। लेकिन उसमें एक खास बात है कि हमको प्रूफ करना पड़ेगा कि हम उस देश में लगानी किए हैं, हम उस देश में इन्वेस्टमेंट किए हैं, हम उस देश में कुछ भी किए हैं। अगर हम वो नहीं कर पाएंगे तो हमारा ये केस नहीं बनेगा और हम हार जाएंगे केस। उसमें एक खास बात ये कि हमको गवर्नमेंट के साथ कोई ये आर्बिट्रेशन का समझौता साइन करने का जरूरत नहीं है, कोई जरूरत नहीं है। क्योंकि उसमें गवर्नमेंट जब वो इक्सिट कन्वेंशन, जब बीआईटी वो जब साइन करती है, द्विपक्षीय लगानी का जो समझौता साइन करती है, उसी में लिखा होता है कि अगर कोई विवाद होगा तो आपको आर्बिट्रेशन में जाना ही होगा। अब गवर्नमेंट साइन कर देती है, कहती है हाँ जरूर हम जाएंगे। तो अब गवर्नमेंट उसके बाद ये नहीं कर सकती कि ना 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 हम नहीं जाएंगे आर्बिट्रेशन में, ऐसा हो ही नहीं सकता, उनको जाना ही पड़ेगा। बस हमको प्रूफ करना है कि हम इन्वेस्टमेंट किए हैं, बस इतना अगर हो जाएगा तो हमारा इन्वेस्टमेंट आर्बिट्रेशन हो जाएगा। अब आप सोचिए कि हम क्यों जाएं इन्वेस्टमेंट के लिए। हम हमारे पास दो चॉइस है, कमर्शियल और इन्वेस्टमेंट, हम लगानी वाला हम कैसे चूज करें, कैसे कैसे महसूस करें कि कौन सा करना है। उसके लिए आपको ये सोचना पड़ेगा कि आपको चाहिए क्या। अगर आपको अ, पैसा चाहिए, जितना आपने लगाया है उतना रिटर्न चाहिए, तो उसके लिए अच्छा है कमर्शियल वाला ले लीजिए। क्योंकि उसमें क्या होगा कि आर्बिट्रेटर जो जो उसमें डिसाइड करेंगे, वो आपको बोलेंगे अच्छा इतना आपका नुकसान हुआ, हमने आपको दे दिया। लेकिन उसमें एक प्रॉब्लम है। अब जैसे हमारा ऑयल कंपनी है और माइंस एंड मिनरल्स का है, चाहे हाइड्रो पावर है, जल विद्युत वाला है, हम बनाए उसमें। अब हम उतना पैसा लगाएं, हम चाहते हैं कि उसको हम 10-20 साल तक चलाएं, जिससे कि हमको बिल जितना आए उसमें से हम कलेक्ट करें और हमारा इन्वेस्टमेंट कवर हो जाए। अब गवर्नमेंट नेक्स्ट डे जो है सो हमारा ले लेती है, हाइड्रो पावर ले लेती है मेरा फैक्ट्री। अब उसमें तो हम कैसे पता करेंगे कि हमारा लॉस कितना हुआ? क्योंकि अगर कमर्शियल कॉन्ट्रैक्ट, कमर्शियल वाला में, वाणिज्य वाला में आर्बिट्रेशन में जाएंगे तो उसमें ये प्रूफ करना बड़ा मुश्किल हो जाता है कि हम कितना कमाते 20 साल में। लेकिन अगर इन्वेस्टमेंट वाला में जाएंगे तो हमारे पास ये चॉइस है, क्योंकि उसमें हम कर सकते हैं कि गवर्नमेंट ने रूल बदल दिया, इसके लिए हमारा असमय नुकसान हो गया, और वो असमय नुकसान होने के कारण हमारा जो प्रिडिक्शन था, हमारा जो प्रोजेक्शन था कि हम इतना कमाएंगे, हम $1 बिलियन कमाएंगे, अब वो मेरे हाथ से निकल गया। तो हमारा तो वो अपॉर्चुनिटी लॉस हो गया, हमारा तो मतलब वो मौका निकल गया मेरे हाथ से बिजनेस का। अब इसमें हमको चाहिए आगे वाला भी बिजनेस। तो ये वाला प्रूफ करने में, ये वाला इन्वेस्टमेंट आर्बिट्रेशन में, ये लगानी वाला में विवाद में ये आसान होता है प्रूफ करना, क्योंकि उसमें हम प्रूफ कर सकते हैं। लेकिन कमर्शियल वाला में थोड़ा दिक्कत हो जाता है उसमें। लेकिन ऐसा नहीं है कि नहीं हो सकता है उसमें भी, लेकिन आपको काफ़ी करना पड़ेगा। और लॉ में आपने पढ़ा होगा वो डैमेजेस का कंसेप्ट और ये सब, तो वो सब आ जाता है। प्रॉब्लम ये है। तो इसलिए
थैंक यू।
हम लोग कहते हैं कि गवर्नमेंट अगर इन्वॉल्व है तो जाइए। लेकिन प्रॉब्लम है, अगर मान लीजिए आप गवर्नमेंट के अगेंस्ट जीत भी गए लगानी वाले विवाद में, तो क्या? आप तो जाएंगे गवर्नमेंट से पैसा लेने के लिए, गवर्नमेंट बोलेगी आइए हमारे कोर्ट में, और हमारे कोर्ट में आइएगा तो बोलेंगे हम आपका अवार्ड ही नहीं एनफोर्स करेंगे। तब कैसे होगा? आप अपना ही कोर्ट अपने गवर्नमेंट के अगेंस्ट तो कभी नहीं जाएगी। अगर हम जाएंगे फॉरेन कोर्ट में तो फॉरेन कोर्ट हमको थोड़े सपोर्ट करेगी, अपने गवर्नमेंट को सपोर्ट करेगी। प्रॉब्लम ये है। और यही प्रॉब्लम है इन्वेस्टमेंट आर्बिट्रेशन में, जो कि कोई ऑनर ही नहीं करता अवार्ड को। इसीलिए अब ये बोला जा रहा है कि अरे काहे को लड़ रहे हो, क्यों जा रहे हो उसमें विन और लूज सिचुएशन में? चुपचाप मेल मिलाप कर लो, जो आप लोग कहते हैं मीडिएशन का मेल मिलाप में, नेपाल में मेल मिलाप कर लो, और दोनों पार्टी, गवर्नमेंट का भी इज्जत रह जाएगा, इन्वेस्टर का भी पैसा निकल जाएगा, बिजनेस रिलेशनशिप भी बना रहेगा, और आगे का भी काम होता रहेगा, हल्ला हंगामा नहीं
बहुत
इसमें।
बढ़िया।
बस इतना ही करना है उसमें और आपका काम हो गया।
बहुत बढ़िया राजेश जी, थैंक यू सो मच।
सर एउटा जिज्ञासा
प्रहरी जी,
राख्नु छ,
या प्लिज
जिज्ञासा राख्नु पर्ने भयो कि कस्तो भने
छोटो छोटोमा राखौँ है, उहाँ
हस्
धेरै
हस्
रात पनि।
जस्तो जेबी छ है, जेबी लाइक वान
हाँ
कन्ट्र्याक्टर फ्रम इन्डिया, रेल एन्ड इंजीनियरिंग कंपनी एंड
हाँ
आवर डोमेस्टिक कॉन्ट्रैक्टर, वो क्या होता है, देशीय अंतर्देशीय वो कॉन्ट्रैक्ट?
हाँ। तो उसमें उसमें क्या है ना कि अगर फॉरेन पार्टी और लोकल पार्टी मिल के अगर एक जॉइंट वेंचर बनाता है,
जी
ये जॉइंट वेंचर इसलिए बना है क्योंकि आपका लोकल कानून में फॉरेनर्स को अलाउड नहीं है 100% ऑपरेट करने के लिए। इसीलिए तो इसके मतलब हमने आपके कानून के हिसाब से ही किया है। इसका मतलब मैं तो हूँ ही फॉरेन, हमारा विदेशी लगानी हूँ मैं, विदेशी इन्वेस्टर हूँ, लेकिन आपके लोकल लॉ के कारण हम कुछ करना पड़ा। तो हम जितना इन्वेस्ट किए 50% ही ज्वाइंट वेंचर में वो मेरा है। और वो अगर आप मेरा डिस्टर्ब करेंगे, लेंगे, हमारे बिजनेस में कोई भी असर होगा, तो वो हमारा लगानी विवाद भी हो सकता है। लेकिन उसके लिए फिर हमको जाना पड़ेगा वो बीआईटी में, बायलैटरल इन्वेस्टमेंट ट्रीटी में, देखने के लिए। लेकिन अगर हम ये वाणिज्य वाला में जाएंगे, तो उसमें हमको सिर्फ अपना कॉन्ट्रैक्ट लेना पड़ेगा, दिखाना पड़ेगा कि भाई हमने ये दिया है, वो दिया है, हमारा आपने ले लिया है, तो हमें वापस कर दीजिए। तो ये चीज़ है। तो 90% ऑफ केसेस वेयर द फॉरेन, जहाँ पे कि विदेशी लोग जाके जॉइंट वेंचर बनाते हैं और तब इन्वेस्ट करते हैं, तो उसको भी इन्वेस्टमेंट ही माना जाएगा।
गुड,
ये
गुड।
अंतर्राष्ट्रीय है ना ये भी?
हाँ, अंतर्राष्ट्रीय होगा, या
अन्तर्राष्ट्रिय,
अंतर्राष्ट्रीय, हाँ।
अन्तर्राष्ट्रिय। प्रहरी जी प्लिज, तपाईँको हात उठिरहेछ।
Sir. So my question is, you've just mentioned that if the case is like investment, but let's say can you hear me, sir?
Yeah,
या
I can, yeah,
Okay.
very clear.
So if it's like if it's treated as an investment, and but the party needs to prove that they have invested some amount in that nation, right? So let's assume that the dispute was in April 2024, and while the ongoing dispute, the another party, even though they didn't have any investment, they decide to uh, prove their investment in 2025. Will that work, or will that be considered invalid?
So at least they have made the investment or not?
They made the investment after the dispute,
Okay. But then
just to be eligible, kind of a.
no, then that will be time bound. In the is a there's a concept of temporis, and
Mm-hmm.
that's why I said that your investment will be counted after the signing of the BIT.
Oh,
So
okay.
at that time, so the one question is that you can't say that, well, I invested in 2025, but my dispute arose in 2024. So then that must be a dispute on something else. It can't be on investment, because you are yourself saying that in 2025 I have invested. But if you have, say, for example, the BIT was signed in 2021 and you invested in 2024 and your dispute arose in 2025, then that's fine. It's okay. The only thing you have to prove that whatever you have done, whichever the commercial activity you have done, it falls within the definition of investment as agreed in the BITs, in the bilateral investment treaty. So just find it over there. And 90% cases you will find so wide, so big, that your investment will somewhere it will fall into that. Even, for example, claim of money is good enough in that one.
या थ्याङ्क यू।
Okay. Thank you. And
अरू
sir,
कसैले केही सोध्नु छ
just
छोटो?
sir, just one question. Can I,
Yeah,
Yes.
may I?
yeah,
Yeah,
yeah.
yeah, please.
Yeah, you've just mentioned earlier that India doesn't consider investment, like investment, but consider all the investment as a commercial arbitration.
Mm.
Correct. Please correct me if I'm wrong.
No, no, you are very right. Actually, initially, India
Mm-hmm.
signed 86 BITs.
Mm-hmm.
86 BITs and several FTA. But only when they had a case against White Industries against an Australian company where India lost that case. And after that, they said that is very bad. They don't want to get into the investment dispute anymore. And then they stop. Like, they withdraw from every BIT after that. And they cancel every BIT. They say that we are stopping it, we are canceling it, withdrawing it. Means now they have renounced that. So now they say that every investment is a commercial dispute. That's the Indian position. But very recently, a committee has been set up to draft the draft model agreement on investment. So it seems like the government is now considering back again.
Oh, okay. Thank you.
So earlier they consider investment dispute as investment dispute. Only after 2010, 12, they had a dispute. No, 14, yeah, 12. From 12 onward, when India lost the case, then they withdraw from the agreement, and then it has become all investor. Every investment dispute they consider now as a commercial dispute.
Thank you so much, Rajesh ji. It is midnight in your country. Even though we are in evening, even though you are doing so good to us, it is really a privilege to us. We are really thankful, and I would like to offer our sincere thanks on behalf of all our participants. Thank you
Matrika
so much.
sir,
Yes, yes,
excuse
please.
me.
Yeah,
I have one question in chat. Could you tell us,
yeah,
Rajesh
please.
sir,
You can
regarding
speak.
this
So,
domestic arbitration in the Australian continent law influencing for the provincial, the three
Uh,
tiers of the government, especially for this commercial utility related matter? This is a
in
very
Australia.
generic questions from my side, very short and sweet. I am expecting from your side as
Okay.
well.
Uh, okay. Australia also have adopted the model law. So far as international dealt exactly in the same way as we know about under the international model law, but Australia is also a federal state, so where the state also has a power. So some of the projects like which belongs under the domain of a state, the state rule will apply. So sometimes you will be very surprised that a contractor or a person from Victoria or like Melbourne is dealing with the Sydney person because they come from two different estates. They also interact and deal with in the same way. They are like a foreign parties in
Yeah.
that one because they come from two estates. So sometimes we have to follow the same mechanism for, say, for example, a court order from Sydney to enforce it in Melbourne, or an arbitration conducted in domestic arbitration conducted in Melbourne to be enforced in Sydney against a Sydney party, and we have to follow that. So there is a domestic side of it, and this is what we do. But is there any difference? The answer is no. Actually, the Australia is a quite mature jurisdiction, so they follow the same principle which we follow in international arbitration. So the basically domestic arbitration is also run like an international arbitration, and we have a Kika here, which they take care of all these disputes, and we can go. But another interesting part is that in Australia there is a mandatory that if there is any civil dispute, it will go for mediation first. So all these dispute will come under the civil dispute. Even if it's a commercial, actually it's a civil dispute in a broad sense. So if that case, then in that case, like, every case has to go for the mediation first. And then it will go to the like court over there, and then they will sign. But if the same party has signed an arbitration agreement, then they will just start the domestic arbitration as if they are doing a regular arbitration. That's what it happens, and that's the impact. And again, we learn from each other the practice, and generally the court refer to a different jurisdiction, different state, and they say that they have decided. And actually, when they draft a law, they have a coordination committee, so they make the law also almost similar in every places. If it is related to commerce, trade, and between the two states, they keep it simple. Administrative law might be little here and there, but most of the commercial laws are same.
Thank you so much, Rajesh ji.
Thank you.
Thank you.
पुनम जी सुन्दै हुनुहुन्छ?
हजुर सर, हजुर भन्नुहोस् त।
अब यदि तपाईलाई फोटो खिच्नु पर्छ भने सबका क्यामेरा अन गर्नु भनेर फोटो सुट गर्नु होला, पर्दैन भने बन्द गरौँ है।
फोटो सुट गर्नु सबैजनाको एकैचोटि नदेखिँदो रहेछ सर, अनि त्यो स्क्रल गरेर गर्नुपर्ने रहेछ कि, त्यही भएर।
ए हो, ल भइहाल्यो, हस् हुन्छ है त।
नभए एउटा हजुरहरूसँगको हाम्रो राजेश सरसँगको फोटो एउटा लिइहाल्छु नि त मैले।
त्यहाँ कति देखिन्छ, ल भइहाल्यो। देखियो भने लिइहाल्नु, भएन भने छोड्यौँ है।
ओके सर, 1 मिनट है त।
हस्।
Do you want me to take out my Nepali cap and scarf and
पुनम जी भयो?
हजुर भयो सर।
Good. Thank you.
Thank you so much, Rajesh sir.
Thank you.
Rajesh sir, thank you so much.
Good night, शुभरात्रि।
Thank you.
शुभरात्रि।
Welcome to
आप सब लोग पढ़ लिख के और होशियार बन जाएं और लीडर बने अपने फील्ड में, अपने कंट्री में।
Thank you,
यही
sir.
हमारी
Thank you.
शुभकामनाएं हैं।
Thank you.